You may be seated. Ms. Grubb, anything for the record?
No, Your Honor.
Ms. Nashi?
Yes, Your Honor, but I'd like to do it once the witness is outside the courtroom.
Okay. Sir, you're excused. Remember my instructions yesterday?
Yes, Your Honor.
We'll see you back in 15 minutes. Yeah. Ms. Menashe?
Thank you, Your Honor. Your Honor, I just wanted to note, I've certainly let it go, but I think at this point it warrants putting on the record that we are getting and/or actually at a cumulative point with respect to the evidence at this point. It is 10:30. We started at 9. There's been very few sidebars to eat away at time, and we aren't even through 2 patients. Dr. Eli testified. I think the record speaks for itself as to whether and how much crossover there is in the same document shown to Dr. Eli. But, Your Honor, I think at the pace we're going, over an hour per patient, I think it certainly warrants the court's consideration as to cumulative.
Okay.
Your Honor, I don't know how the state can ask this officer, this doctor to opine unless we place on the record why he's doing it and his various reasons. He is not the same boarding as Dr. Ely. His practice is different than Dr. Ely, and he has different opinions than Dr. Ely. The opinions are similar, but they're not identical. And I feel that the state of Ohio is deserving of a full examination of our witness. This case is too important to the people of this state and to the defendant to not have a full and fair airing. I will say this. Ms. Belisari was one of the longest hospitalized patients. She's one of the older ones and has a more complicated medical record. I think the medical record is in like 3 volumes, 2 or 3 volumes. So getting through her was important. We have many upcoming alleged victims whose stay was under a day. So those cases will go very quickly.
Okay. And look, is there something you want to add?
Not to this topic.
Okay. Looking at 403, I agree the foundation's differently in the specialty, so I'll permit it at this point in time, but you would have covered every of this witness. I think you've covered the whole aspect. But it's not cumulative at this point in time. Okay, next issue.
Yes, Judge. We at this time would like to address the improper and outrageous conduct by Ms. Grubbs in the last exchange of this witness, when she improperly started with her commentary about the murder. Now I want to discuss the murder of Brian Hayes.
Okay.
That's not a question. It's an outright argument, and it's a conclusory argument. And I was thrown back by it so much before we objected that I wanted to make sure we heard her correctly. And at that time, I brought it to Ms. Menashe's attention, who was busy retrieving documents at the time. We asked that she come over to us so we could speak with her briefly, quietly, off the record, to confirm that that's what she actually said. Ms. Grubbs, I've heard her over the course of a month speak low many, many times, but at this time she decided to create a closing argument again and say, yes, the murder of Brian Hayes, that's why we're all here. And so much so that utilizing the word murder 3 times in front of the jury, I think it was a outrageous outburst on her part, strictly geared towards shock appeal and so that the jury could hear what she was saying. Now, if that kind of conduct is permissible in this courtroom, I have plenty to say to the prosecutors in between questioning, and plenty to say about Dr. Husel's innocence and how he's wrongly being persecuted in this case. And I could get up here all day and have this type of commentary, but I certainly don't think that's proper in any courtroom, and that's why I bring it up to your attention, and I ask that the prosecution be admonished for such behavior, and that it not be permitted to happen again. And we would also ask that the jury disregard Ms. Grubb's extrajudiciary comments, because they're not in the line of questions. They were completely improper and borderline prosecutorial misconduct.
Okay. Well, factually, she said alleged murder when she was there, even though there was a pause between the two, and even though she was facing one direction and went the other direction, she did have the alleged beforehand. Okay?
It's still not a question. It's not a proper question. She's she's sitting there talking about what she's going to do about the alleged murder. I didn't hear the word alleged, which is understandable, because that's why I needed to clarify from her. But I heard the word murder, and for her, and I know there was not a question pending, and it was not in relation to a question. She has no right to get up there and give a conclusory comment about murder without asking any questions to the witness. And I think that is the issue that's improper here.
Okay. This was the directional comment that she made going to count 2. I just want to make sure we're talking about the same incident.
Yes, sir.
Okay. Ms. Grubb.
Thank you, Your Honor. I did use the term alleged. It was a transitional comment, which I think we have to use to turn from one count to the next. And this is a murder trial. There are 14 counts of murder alleged. And I think we ought to be able to use the name of the crime that we're here for. So if the court feels that I overemphasized it, I'm sorry. I will make sure not to use it 3 times in a row or twice in a row. But my intention was to focus everyone on to count 2 of the indictment, which does allege the murder of Ryan Hayes.
Okay. Anything else?
No, Your Honor.
Anything else?
Yes, sir. First of all, I'm fascinated by this new evidentiary concept called transitional, which we have objected to repeatedly in this case. That aside, it does not give a lawyer the right to make commentary, which is the ultimate decision of the jury. And I agree, we're here for a murder trial. So when I ask a witness, did you conspire to commit murder with Dr. Husel, I should be permitted to ask that question, but instead it's objected to because, I mentioned the murder word. So, you can't have your cake and eat it too. And in light of this, it still sidetracks the main issue, which she got up there and made a comment that was a conclusory comment to this jury without a question pending. And then she came over here and spoke loudly and mentioned the word murder 3 times. And that's why we're all here, for a murder case, because of the murder. And she knows that's improper. Absolutely knows it's improper. To sit here, we're trying to speak to her and clarify an issue. And she intentionally blurts out our conversation loud enough for the jury to hear. That's a problem. That's not proper conduct in a courtroom. She knows better. And while I never tried a case about her, I know enough about her background to know that she knows better. And having said that, I think it's impermissible, and it shouldn't be tolerated.
Okay. In reverse order, addressing your argument, 611C deals with leading questions. Transitional questions are always permitted. Okay? I don't know what you're basing your concept on, but it's been a common practice if I'm switching subjects to be able to use leading to go into the subject to switch it. Now, as to being testimonial or anything, that's a different issue, and it's question by question, okay? Relative to her comments there, both sides have been addressing in with the concepts of co-conspirators on your side versus this murder thing. It is 14 counts of murder. The alleged murder in transition, I do not feel that that's prejudicial to you, okay? The repetitive nature is due to the number of counts. I would ask the state to not highlight it for every count. I mean, you have to transition. The offenses occurred in count 2 or something like that, but it eventually does get cumulative in effect. So let's go through it guardedly, okay? I do not particularly care for the comment about transition made by you, Mr. Baez. You know, it's 611C, okay? Ohio Rules of Evidence. So as to any objection on that, I don't feel it's well-founded. Anything else?
The only other issue that I would ask is that she not show me documents. She knows I'm not on the floor. There's nothing I could do in reference to documents being shown. I think it's a bad look for the jury for her to be showing me documents and I have to ignore her or point her in Ms. Menashe's direction. She's done that repeatedly. If there are documents that she needs to disclose to Ms. Menashe, I ask that she do it directly to Ms. Menashe. I don't want to get in trouble with the court, and I'm trying to respect the court's rules, and for that reason, I ask that she be so instructed.
Okay. I have my rule from day one. I've told everybody, the one on the floor is the one who's involved. Was Ms. Menashe not available?
She had her back turned and was talking to, I think, co-counsel. And for context, what I was presenting was, I believe, part of the medical record, which has been stipulated, and it was a pro forma, here it is kind of thing.
Okay.
But if that's not acceptable, I stand admonished.
I have been consistent from day one. The one on the floor is the one who deals with issues. Okay? So we'll leave it at that. Anything else for the record?
Your Honor, I believe Mr. Zion wants to
Yes,
address
Mr.
it.
Zion?
Want to do it at noon, or?
Yeah, it's nothing that we've talked about at this point. It's my understanding at the sidebar there was some talk about the lessers and stuff, and I would just like to put that on the record and discuss that a little bit. But that's nothing we can do now. I'm sure people have a few minutes to go to the bathroom.
Okay. We will stand in recess. We'll get started at 15 till, which is 3 minutes. I think we might not start at 15 till because I know my court reporter needs a break.